Before we get started, we'd like to thank Nationwide for sponsoring this episode of Let's Get Surety. When you partner with Nationwide Surety, you know you're working with a strong and stable carrier that has a wealth of experience. Nationwide Surety Operations specializes in both commercial and contract surety bonds to support local, regional, national, and international customers with operations in the United States. For more information on Nationwide Surety Solutions, visit nationwide.com/surety.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Thanks so much for joining us for this episode of Let's Get Surety. Today, we are excited to be talking about court and judicial bonds, fiduciary bonds. I've got my co-host with me, NASBP CEO Mark McCallum. Hey Mark, thanks for being on.
Hey Kat, we've got a great topic that I think every producer needs to know about.
Yeah, agreed. I mean, this could be the recession-proof bond, right?
Absolutely.
So to talk about this and really dive into court bonds, we have with us Susan Jordan, who's Regional Surety Leader with Westfield Surety. Hey, Susan, thanks for being on.
Hey, Kat. Hey, Mark. Thank you so much for having me and for talking about this topic, which I really enjoy.
Well, we're excited to talk about it. But before we really dive in, can you tell us a little bit about yourself and about Westfield?
Absolutely. Well, I started in the surety industry actually 40 years ago.
So you're just a newbie, Susan?
Yeah, I know. Don't do the math. I don't want to hear the calculator going. That makes me very old. So I started back when we did everything as an underwriter, contract, commercial, fidelity, everything. So about 20 years ago, I chose to specialize just in commercial surety. And that's kind of when the industry started moving towards specialization. And I just like the diversity of commercial surety. So that's what I do at Westfield. And Westfield's been in the contract surety business for over 60 years and chose to move into commercial surety a number of years ago. And so that's what I do with Westfield. So today we're going to talk about court bonds, which I particularly like. And as you mentioned, it kind of has been what I would say recession proof during this pandemic because a lot of industries have struggled, but there's always been court bonds, fiduciary bonds. So they have maintained their bond needs during that time.
Is that what has made court bonds such an interesting topic for you? I know you've written on this topic pretty extensively as well.
Yes, I like it because it's always different. And you never know. Every case is different. So if you want, we'll move right into the topic.
Oh, that'd be great, Susan. I know, Susan, the word court's kind of a big word. Could you give us a little bit more definition around what you mean by a court bond?
Okay. So first of all, judicial bonds, which is also court bond, it's generally required in a civil court proceeding when you have a litigant that is seeking a remedy in advance of a court decision. So the bond guarantees that if the opposing party incurs damages as a result of an action, they'll be made whole. So basically, each party has rights that are protected by law in the court. So, for example, Kat, if I were to file some sort of complaint against you for whatever reason in a court, then the judge can hear the case, but they're going to require me to post a bond. That bond is to protect you. I've basically been dragging you into court for whatever reason, but the bond is to protect you. In the event I've taken you to court and the judge says, I really didn't have the action to do that, that bond is going to protect you for any kind of damages. So court bonds vary for all types of actions, and there's generally two types of court bonds, plaintiff's bonds and defendant's bonds.
Well, it sounds like they're pretty important. I know litigation is something that can drag on for quite some time. And as you said, either party may be damaged if this continues. So I think that court bond plays a very important role.
Well, that's correct. It does. And it's required by the court. The court actually will establish the bond amount. So there are all types of court bonds depending on the action that's filed in the court.
So, Susan, when you say the court determines the bond amount, is there kind of a general rule of thumb how they get there? How do they arrive at that amount?
Well, depending on the complaint that's being filed, for example, the damages that are involved, and I can get into a couple examples or specifics, and I'll cover a few different types of bonds and give you a couple of examples. But if there's a dollar amount that is being claimed, and there are some statutory requirements that require a bond amount above the actual claimed amount, and that statutory requirement takes into effect fees, damages, and things like that. And there again, that bond amount is established by the court.
And would that also include potential interest?
Yes, it can.
Okay.
Yes, it can.
Great.
So there's two types of bonds: plaintiff's bonds and defendant's bonds. So plaintiff's bonds are for the benefit and protection of the defendant. So should the plaintiff, who actually filed the action, loses the lawsuit, then the plaintiff is liable for damages that the defendant suffers. So the plaintiff voluntarily started that litigation. So the plaintiff bond, for example, we see a lot of attachment bonds. That's a type of a plaintiff bond. So the state statute can vary as far as the value or the amount of the bond. A plaintiff is claiming recovery of some type of goods. They're actually wanting to attach something. So say a company leased equipment. Say I leased you printers, scanners, something like that. The other party defaulted and didn't pay. I have the right to go and attach that property. So I would go through a civil court and file a complaint that you hadn't paid for that property, and the judge would say, okay, you can attach and go after and reclaim that property until we have our day in court. So I'm attaching that property, but they're going to require me to post a bond until we actually have our day in court. Another type of plaintiff bond is the preliminary injunction bond, which is also called a TRO, or a temporary restraining order. And that can be when an order is issued by the court where the defendant is required to refrain from doing something. And an example of that, we see a lot of these, is a violation of a non-compete. And you can have a plaintiff file an order against, say, an ex-employee who takes a list of customers, they violate that non-compete, and that's a temporary restraining order or a preliminary injunction. And the order is to get that defendant to stop from doing something. So that's another example of a plaintiff bond. The other type of court bond we see is defendant's bonds. So the purpose of a defendant's bond is to regain or retain possession of property pending the outcome of a lawsuit. And it's also to block a plaintiff's action to satisfy a claim, such as an appeal bond. So that's probably the type of bond you hear the most about, is an appeal bond. And you think of a defendant's bond, you have two parties in a court bond, a plaintiff and a defendant. The plaintiff is the one who actually voluntarily seeks an action. The defendant's the opposing party. So if you have a defendant's bond, that's the party who is blocking a plaintiff's action. They've already been sued. And in this case of an appeal bond, they've already lost a suit, and they are appealing a suit. So the party is dissatisfied with a judgment in a lower court, so they may want to take it to an appeal to a higher court for reconsideration. So in an appeal situation, the bond guarantees payment of the judgment plus interest, cost, damages. So I think I read somewhere that it's estimated that 85% of the cases are unsuccessful. So you can imagine appeal bonds are quite hazardous for the surety.
Right. Hey, Susan, is there also another term for an appeals bond that you hear out there?
Supersedious. You hear supersedious.
Right.
All basically same type of action. And another type of a defendant's bond that we see a lot of is a discharge or release of a mechanic's lien. That type of bond covers liens that are filed against real estate property and or for money due for work materials used in constructing property. So if a lien's been filed against property, the owner of that property, they're unable to get a clear title. So if someone's building commercial property or a real estate, whatever, say there's a dispute for materials, work that's been done, that contractor or subcontractor can file a lien against the property. Once that lien's been filed, then that person, the owner, cannot sell that property. So the release of lien bond, that's another defendant's bond because that lien's been filed. The release of lien bond releases the lien, clears up that title so that owner can file that property until they have their day in court and can decide who owes what. So there again, that's another hazardous bond for the surety, and the bond guarantees, as determined by the court, what is due the claimant. So those types of bonds, there are two different types of court bonds, both plaintiff and defendant. Underwriting of those are both a little bit different.
All right, so there's special considerations when you're underwriting plaintiff versus defendant bonds. Can you go into that a little bit?
Yes, absolutely. So you want to, as an underwriter, you want to review the complaint, determine what the case is about, and you need to also look at the principal that you're bonding, the financial statement of the financial condition of the principal. From an underwriting standpoint, underwriter can't determine the outcome of a case. So underwriters always look at the worst case scenario. And with a court situation, even though it's a plaintiff's bond, you never know how the case is going to turn out. So depending on the amount of the bond, say the bond's $100,000, you still have to assume potentially the plaintiff could lose the case and have to pay that $100,000 to the defendant. So financial statements required. We very much look at and rely on the attorney that's handling the matter. So we do look at the attorney that's involved. And we also look at the bond form. The bond form is oftentimes drawn up by the attorney. It's case specific, and you want to make sure that the bond limits the liability to the penal sum of the bond, which is very important because if the surety's on the hook for $100,000, you want to make sure that that bond limits the liability to that $100,000 because you can get certain situations where the court case is settled and the surety can be on the hook for damages in excess of the penal sum of the bond. Oftentimes with defendant's bonds, collateral's required because as I mentioned with defendant's bonds, they've lost once, chances are good they might lose again. So the standard requirement on defendant's bonds is oftentimes 100% collateral. And I don't think I mentioned before, courts require bonds. It's a statutory requirement. Therefore, they're not in the position to hold the cash themselves, and they require a bond as an instrument in the court proceeding as opposed to a letter of credit. or cashier's check, which you sometimes see to replace other bonds in different situations.
No, that's fascinating. Susan, earlier you had mentioned another type or class of fiduciary bonds. Could you tell us a little bit more about that? I imagine that's kind of a broad class of bonds.
Yes, fiduciary bonds, also called probate bonds, and they are also filed and held by the court and overseen by the court. So a fiduciary is a person, a bank, an attorney, individual that's appointed by the court to handle the affairs of another who for some reason is unable to handle their own affairs. So in that case, that fiduciary is a person, well, the bond guarantees faithful performance of their duties as a fiduciary. So the most common types you see are administrator bond, executor bond, guardian, and a conservator. So the administrator handles the estate of a deceased. An executor, the only difference in that term is they're named in a will to handle the estate of a deceased. They protect the heirs and the creditors. There are strict guidelines imposed by the court that they must follow. They have to distribute the assets in the estate, pay creditors, distribute assets, things like that. The guardian is over minor children. If, say, a child under the age of 18 is left life insurance from a grandparent, something like that, the court may require a guardian bond, or if both parents are deceased and that child receives a sum of money, the court, and there again, the court's position is to protect the assets of those who cannot protect the assets themselves. And they determine a minor is a child under the age of 18. A conservator is an individual that is considered legally incompetent, someone that has been determined unable to handle their own affairs. So as far as from a surety standpoint, these are all obligations that are filed with the court. As with other court bonds, the surety cannot get off these obligations until released by the court. So once the bond is filed with the court, the surety is on the bond until released, and some can be very long term. You can have a conservator bond of an incompetent, can be a fairly young incompetent that's had a brain injury. You could be on that bond for years. The minor bonds, you know when the bond obligation will end, and that's when the child turns 18. Administrator bonds depends on the size of the estate. But there again, this classification of bond has pretty much maintained bond needs throughout the pandemic, although courts were shut down, cases were held virtually, things like that, but bond needs remained pretty steady.
Susan, I imagine with these kinds of bonds, the nature of the fiduciary's commitment and their background is probably pretty important to the underwriting process. Would you agree with that?
Yes, absolutely. So in order to underwrite the fiduciary, we look to qualify the principal, we pull a credit report, and the reason for that is we look to see if the individual can manage their own personal affairs, then we obviously hope they can manage the estate of someone else. And we also look for attorney involvement, because managing an estate, you have to follow the court's guidelines. We also look to see what the estate consists of. Is it all cash? Do they have stocks, real estate, things like that? We look to see if there's an ongoing business that can make an estate very complicated to deal with. Also, there can be litigation in estates. So there's a number of things, lawsuits. We see it all when it comes to an underwriter. So as I think I had mentioned, the hazard involved is this can be a non-cancelable. It is a non-cancelable bond. So once you're on the bond, you cannot get off until it's released by the court.
Wow. So I mentioned there are certain red flags you look for when you're underwriting.
Yes. And qualifying the principal is obviously a big one. And are they able to manage that estate? And like I mentioned, an ongoing business, things like that. Obviously, attorneys handle the estates. Many of them do, which is ideal. They're a disinterested third party when it comes to handling estates. So, we look to attorney involvement a lot. Premium collection can also be an issue with these bonds many times because you can't get off the bond. So it's a business that we see a lot of. And it's, as I mentioned too, during the pandemic, it's been a steady flow of business. Even though courts have been closed, they've had virtual meetings. It's been a little bit slower, but it's been a steady bond need throughout the last couple of years.
I would think with an aging demographic in the U.S., there's going to be even a greater need for these types of bonds. Is that something that you're seeing or anticipating?
Yes, absolutely. As long as I've been in this business, this has been one area of bonds that has remained constant. It's not been replaced. It's something that I've seen very, very viable. I have a lot of agents that have made a living off of this type of bond.
I'm glad you brought that up. I wanted to touch on a little bit more about kind of how you see this being such an attractive area for agents, particularly if they're interested in maybe learning more about this and expanding their own book of business. Maybe give some pointers to agents on how they get established and what some of the best practices are in securing this kind of work.
From my point of view, the agents and having relationships with attorneys.
Okay.
Attorneys are a great source of business. And the attorneys that are particularly involved with the estate and probate business, they're going to get the most opportunities in this type of business, as opposed to just the walk-in type of business for probate. But the attorneys are just a great source of business, and establishing relationships with law firms and attorneys, it can be a really good source of business. That's most of the business that I see coming in from my agents. It's because they have really strong relationships with attorneys and law firms. And there are attorneys that are appointed by the court. They're called public guardians, public administrators, and they are designated by the court to handle cases that nobody else qualifies for. So they get all these probate cases that nobody qualifies for. So they just basically flood those to those specific attorneys. So agents really can diversify their book of business by developing relationships with attorneys and getting into the court bond business and the fiduciary business.
That's great information. So do courts maintain lists of those public administrators, those guardians, or are there organizations of those individuals that producers could research?
I have been told that the courts do have a list, and those are appointed positions. Okay. So yes, they can get access to that.
Oh, great.
In their counties, they're by county.
Okay. Certainly there seems to be a great diversity in court bonds and a lot of probably very interesting situations that you've come across as an underwriter. Does any one situation spring to mind that you thought was really interesting?
Every day it's something different. And I think that's why I like commercial surety. And that's also why I like the court bond business, because gosh, I think I have seen it all. And
I bet. Yeah.
it is every time a case file comes across my desk, and I am not an attorney. So I should have said that from the beginning, but it is very unique, very different, and it makes it interesting to read through the case file. But from an underwriting standpoint, as I said, I'm not an attorney. I'm looking at it from the surety's perspective and putting a bond on that specific case. So I cannot determine the outcome, but without getting too specific on cases that I've been involved in, there's been all types of class action suits where the company files an appeal that have been very interesting. There's some that have come across my desk that related to terrorism that I wanted no part of. There's been very sad situations with probate cases. It's just runs the gamut. So, but it's been a steady source of business. I will say that.
And it sounds like it's always interesting.
It's always interesting. And when I decided to specialize in commercial surety, it was for that reason. It's just something always a little bit different and always challenging.
Well, you must feel very proud, because clearly these bonds are very important to our operation of our legal system. And without it, it wouldn't function quite as well, clearly. So what a great field to be in.
I think so. I do enjoy it.
Well, thanks so much, Susan, for being on with us today and sharing some information around judicial bonds and fiduciary bonds. Before we let you go, are there any final thoughts or last words of inspiration you have for someone who's thinking about getting into this arena of court bonds?
I don't think so. I think just you have to start somewhere. And I think the attorney relationships is a good place to start. I really do. It's not something you can just learn overnight. It's a lot to understand, but it can be very beneficial to an agent in the end. It really can. So I think it's a very interesting field. But I really appreciate you all having me today. This has been very entertaining. Thank you so much.
Our pleasure. Thanks for sharing.
Yeah, it's been great having you on with us. We'll have to have you back sometime to talk about some other commercial bonding.
Well, I've been in all types of bonds.
Well, thanks so much for being with us, Susan.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.
Before we go, we just want to say thank you again to Nationwide for their generous support of this episode of Let's Get Surety. For more information on Nationwide Surety Solutions, visit nationwide.com/surety.